All right. Thank you everyone so much for coming. We are really excited to be having this conversation, and we're so happy that you can join us. So my name is Theodora Skiatis. I'm the president of Harvard W3D, Women in Defense, Diplomacy, and Development. Oh, there's a comment. Can you hear anything? Can folks hear me?
Yes.
Okay. So I think, Eshan, maybe it's a voice issue on your end. Yeah, so I'm the president of W3D, Women in Defense, Diplomacy, and Development, and we, alongside ANHW, so Harvard Alumni Network for Harvard Women, and the HKS New England Alumni Association, and the HKS Women's Network, which is also a global organization, are really excited to be partnering in organizing this event. So thank you for coming. And now Litsy's going to kick it off with a poll to get a sense of everyone's perspective. So thank you so much for joining. We're really excited to be having this conversation. And thank you, Litzy, for all of your work in organizing this great event.
Thank you, Theodora. For the information for the participants, there's a poll right in front of you. We just want to get a sense of how familiar the audience is about the current affairs in India. So if you could just take a few seconds to fill it, it'll be helpful for us. As the results come in, I would like to introduce myself. My name is Litcy Kurisinkal. I'm an alumni of Harvard Kennedy School. I'm also the president of Alumni Network for Harvard Women, Chicago chapter. Looks like our audience is pretty familiar with Indian affairs, which really would help us during the discussion. So as I said, we have a brilliant panel here with us today. And it's truly a great privilege to have them as our speakers today. Mr. Aakar Patel, he was the former executive director of Amnesty International India, a very bold leader, a bold defender of the defender of human rights during his time in Amnesty International. Apart from that, he is a widely read columnist in India. His writings are very powerful, written without fear or favor. And so his credibility is pretty high among his readers. Thank you so much, Mr. Aakar Patel, for joining us today. Ms. Arundhati Roy, who needs no introduction, but her book, The God of Small Things, and the Booker Prize winner title precede her name. But she's more than that, like her characters in the books, like Anjum, Miss Jabeen, Jannat House from the Ministry of Utmost Happiness. They are like characters that, at least to me, they are part of my family. It's like they're living with me. She has written extensively on various social issues, which kind of tempts at least me and many others to label her as a social activist or a political activist. But she prefers to identify herself as a writer. But her writings have definitely influenced many to look at social justice from a different perspective. Shadan Farasat, our very own Harvard alumni from Harvard Law School. He is a practicing advocate of Supreme Court of India. He is more popularly known for one very important case that he fought on triple talaq. Triple talaq is an exclusive right Muslim husbands in India had. They could instantaneously divorce their wives by uttering the word talaq 3 times. So Ms. Varisha Farasat and Ms. Shadan Farasat pleaded on behalf of Muslim women's rights organizations, and currently it stands unconstitutional. Thank you so much, Shadan, and welcome home. I'm going to ask Shadan, is the picture so dismal as our fellow, as your fellow speakers have stated? When does dissent become sedition in India? At least according to the laws, what are the guarantees that are given by the Constitution? And when does dissent legally become sedition? And do you think courts are stepping up to guarantee these rights?
Yeah.
I mean, as the advocate.
Yeah, no, thanks, Litzy. So I'll answer your question, but before that, I'll just frame it. I think it's not just a question of dissent, but like Arundhati said, I think we are looking at effectively a complete institutional collapse. And I, as an advocate who regularly practices in courts in Delhi and even other parts of India, I have seen that acceleration very, very fast in the last, say, 3.5 years. I think it's really proceeded at a very, very fast pace, because as advocates, we really do know when we have a fair chance of a fair hearing. And that's what keeps driving us at work, because you present your case and you hope that, okay, if you have the right points, constitutionally or otherwise, you have a reasonable chance of success. And now I think a lot of us are reaching conclusion that, listen, it really doesn't matter what you argue, because even the courts are not in a position to function independently and sort of uphold the constitution. And that has happened right in front of my eyes in the last 3.5 years. So I think that's the sort of context we're looking in. Just to give you an example, I mean, there was a lockdown in India, which was sort of put in a little abruptly, but that's understandable, maybe given the suddenness of the coronavirus situation. But then people approached courts saying, listen, there are problems. Within 1 week, you had people saying migrants is the issue. How will people feed themselves, etc. So you have a government-induced lockdown, which is obviously restricting your freedoms, your right to move, etc. So this is a clear-cut case of a constitutional issue before the court, right? Is the restriction, even as per the Indian Constitution, is the restriction valid under one of the heads? Is it reasonable? These are classic constitutional questions. The court doesn't do anything about it. It says, no, we can't touch it. This is, the government domain. And then the migrant crisis plays out on the roads in India. We have seen how people walk thousands of kilometers without food, without water, pregnant women, all kinds of inhumanity, indignity sort of pushed on them. And then finally, when the court, because of a lot of criticism, woke up to this, it was already too late, because either most of the migrants had already sort of moved and walked and suffered in the process. So I mean this, and they didn't even in those hearings, they didn't really ask the elementary. I'll just give you an example. Interstate migration is entry 81 in our constitution in list 1, which means it's the responsibility of the Union of India, not the state governments. It's the responsibility constitutionally of the government of India to ensure and facilitate interstate migration. But the court, even in that hearing, which it took on belatedly, was so much focused on states doing their job, completely missing the point that it's actually, the central government whose job it is. So, and they didn't even ask basic elementary questions which you expect of them. So that's the kind of institutional collapse we are looking at. And I think that's pretty sad, because what are the options which people have? Either you sort of democratically protest, or you sort of organize people, or you sort of rely on the institutions. And I think increasingly the conclusion for even lawyers is that, listen, institutions are not going to be there for you when you need them. And that's pretty obvious. Just to answer your question now on when does, dissent in that context become, as per the law, and the law is not being implemented, but as per the law, when does dissent become sedition? Is that if you were, because we are effectively criminalizing free speech. So the law is that speech can be criminalized only if it leads to a proximate cause, if it is the proximate cause of incitement to violence, which will lead to basically a damage to the state of a very fundamental variety, that is overthrowing the state as it were, not criticism of a government, not anything which is innocuous, but a very actual incitement, that is a speech which incites violence to overthrow the state, then that would potentially amount to sedition. Anything short of that, as per the law, is not sedition. But like I think the other panelists said, it doesn't matter. Sedition is being invoked left, right, and center for completely innocuous kind of speech, which if I look at as a lawyer, I literally laugh. But then I also, at the same time, even as I'm laughing, I know that if I were to go to a court and actually say this is not sedition and you quash it, I'm going to have a really tough time convincing the court in today's environment. And that's the sort of, irony and difficult situation we are in India today.
Shadan, why do you think it's happening? There was a point of time when people looked upon, codes and judicial activism. We were so proud of judicial activism. And how has it, what has changed and how has it evolved? Or, where is the conscience of, the upholders of the law today?
So my understanding of that is that I think we have really historically overstated the role of the Supreme Court as an institution which has protected rights. I think at all times when you look at when the pressure, executive or political pressure has been applied on the Supreme Court has failed. It did fail during the emergency, and it's failing broadly. I mean, on most issues, it's failing today. There are good individual judges, but matters of consequence don't go to them. Structurally, the whole thing is framed in a way that matters of political consequence don't go to them. So Supreme Court historically, and when we studied in law schools, of course, you'll read the lovely paras which are there in the judgment. But when you look at and closely examine the results of each of those judgments, in matters of pressure, I find the Indian Supreme Court has actually always not really come up to the mark. And so it's a bit of a misnomer that we have really, the Supreme Court was activist. It's been activist when governments have been coalition governments, weak governments, you can push them around a little bit. But with really facing real power, I don't think the Indian Supreme Court has historically shown much of a, if I can say, a spine, for lack of a better word.
I think, you talked about government being the largest advertiser. So I just wanted to kind of, since we are talking about funding, I just want to quickly get to Shadan about the Foreign Contribution Regulations Act, which limits NGOs actually from receiving foreign funding and prevents them from kind of getting involved in political activities. At the same time, Finance Act has given the government or the political parties to receive funding from abroad. So I think while securing their finances of the political party through foreign contributions, which would very well help in their advertisement that would control media, it is kind of really control or defunding NGOs and literally buying dissent in some sense. Can you talk a little bit about that, Shadan?
Yeah. No, so I'll just frame your question again in a slightly larger context. I think what we are seeing in India, I'll answer that, but what we are seeing in India are two things. One is discriminatory application of what are otherwise neutral laws. And second, which is now increasing, is actually de jure discriminatory laws, right? So for instance, I will just take it a little bit away. Delhi riots happened in February when Donald Trump was visiting. And, it's substantially, the properties of and lives of Muslims were lost. And there was a huge right-wing element which was involved in this, the Hindutva wing. But today what we are seeing, although laws, IPC, Indian Penal Code is neutral, we are seeing a very uneven application of a very value-neutral law otherwise, right? And the state is doing it, and the courts so far have not been really able to correct that. That's what we are seeing. So that's uneven application of otherwise a law which is fine. What we're also seeing is that law itself is being turned into a very, very clear instrument of discrimination. And the most obvious example of this was the Citizenship Amendment Act, which consciously sought to exclude anybody who was Muslim from the scope of the benefit of the act. Although even Ahmadiyas and others who are not considered Muslim in Pakistan and therefore would, just by the logic of the act itself, would have been included. So there's a conscious exclusion there. Similarly, in FCR, if now come to your question, what's happening is that you have two bunch of rules which have been implemented. So you have for normal FCRA, just for the audience, is basically foreign contribution in whole range of activities in India is prohibited unless permitted under the specifics of a certain act. Now, so you need to go to the government, you need to take their permission, and then the money can be used only for those purposes. So basically, the idea of the present government was that a lot of activity they assumed, which is happening in terms of, activism or liberal ideas, their allegation was that, listen, this is all foreign funded, which is not correct because there's a whole organic, context to this in India. It has existed here for decades and centuries. Our whole independence movement was inherent, so we don't need foreign funding for that. But they have been targeting foreign funding of all liberal institutions and NGOs, right? At the same time, there was a 2014 judgment of Delhi High Court which said that, listen, the ruling party BJP and also the Congress had received money from a company which is majority foreign owned, that's 50% plus foreign stake, and therefore it was foreign funding of a political party, which is violation of Foreign Contribution Regulation Act. To overturn that, amendment was brought into 2016 by the present government, which basically said that it doesn't matter even if the funding of political parties, it doesn't matter if the company which is funding is owned 50% or more by a foreign entity, till the time under what is called for us a FEMA, it's a separate act, it is within the permitted amount of what investment is permitted in that area or that sector of the company. So for instance, if in telecom, 95% foreign funding is allowed, then a company which is 95% owned by a foreign company, say a US-based company or even a China-based company, could actually be funding a political party without it violating the foreign contribution law, whereas the same money, if it were to go to NGO by the same company, it would violate. So you have two discriminatory practices within the law built in. So now, you're discriminating without any logic. That's one. Now, connect that to what is happening in India in terms of electoral funding. We had a new concept introduced in 2017 of electoral bonds. So in India, the law was that, listen, if you have to fund a political party, a corporate entity had to fund a political party, you have to disclose it to your own shareholders, you have to disclose it, and the party which is receiving the money has to disclose it to the Election Commission under the Representation of People Act. So both these requirements of disclosure on both the ends, that's the donor end and the donee end, were undone by this amendment. And you had a new concept introduced, which is electoral bond, which is you buy a bond, it doesn't have the name of who's buying it, and then you go and deposit it with a political party and they encash it. And the only bank which has been allowed to issue these bonds is the State Bank of India, which is a government controlled bank. So in effect, what happens is nobody knows who's funding the political party except the State Bank of India, because they can match the bond number. So this bond was sold to this company and was encashed by that political party, right? So effectively, the government is the only entity which knows who's funding through this electoral bond process. And therefore, it's not surprising that electoral bonds are a way to completely finance the ruling party of the day to an extent completely excluding the opposition. And that's what is happening. The data, to the extent it's available, shows that 90 to 95% of the electoral bond funding has gone to the BJP. And now match this with the fact that you are allowed to have foreign companies donate in the electoral process. So you can have a 95% Chinese-owned company funding the BJP today and we don't know anything about it, right? And so this is the kind of legal structure we are living in, which is totally, whereas imagine if this was happening to an NGO, how would the government react? So for their own funding, for political party, they're allowing this through a legal mechanism. And again, the courts really, one of the things which is, problem of our Indian court system is they decide by not deciding. So we have, the challenge to electoral bonds has been pending for almost 3 years. Ever since it was enacted, there were a couple of challenges that were there, but it's almost 3 years and it's not been decided. And thousands and millions and crores of rupees have been funded. In the meantime, elections at national level, at state levels are being won in different cycles. So, that's the discriminatory application of law which is happening. And that's a great example where courts have not been able to actually do their constitutional job so far.
Thank you. Shadan, do you want to give a quick, quick response on, do you have hope in our Supreme Courts and institutions in general? You have like 2 minutes.
Yeah. No, of course, the situation.
I know the audience is really waiting to ask you questions, so I don't want to deprive them of it. Yeah.
Yeah, I'll take 1 minute. So yeah, I agree. I agree with Aakar that I think a larger sort of democratic challenge is really the way forward in terms of raising issues. The CA protest was one such thing. I think it surprised all of us. I was very positively surprised by the way it came out, and then we are all part of it. But I do think that even within institutions, as bad as the situation may be today, there are small victories to be won even in today's time. And I think we need to keep at it. What gives me hope and confidence is that even though judges may not be able to assert themselves, but when I look at younger people, even the judges, law clerks, and when sometimes you have a conversation with them, they're so honest and they can see what's happening, and even the kind of pressure their own judges are in, and the fact that things are not so. I guess that's the younger generation ahead of us. So for the future, I'm hopeful. I think there's small victories to be won even in sort of semi-compromised institutions that we really live in today. And hopefully sometime in the future, we'll be able to resurrect the court system fully. or at least substantially, maybe not fully. Fully is a very big thing, but at least substantially from, how much worse we have become in the last, say, 5 years or 10 years.
Thank you, Shadan.
Thank you guys so much. This has been an incredibly thought-provoking conversation, and has given us a lot of food for thought, and hopefully also productive next steps. It would be great if we could continue the conversation and substantiate it with follow-up action. But I think that I speak on behalf of everyone when I thank all three of you very much for your generous time, your candor, and your reflections. This has been a really powerful conversation. So thank you very, very much. We really appreciate that.